Thank you, Judge.
Everyone, just one moment for me.
All right.
Oh, please be seated. Yes. It has to be here, right?
All right, for the jury?
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what's called the charge of the court. You do not have to memorize it. You will be given this copy back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Richard Thomas, stands charged in an indictment. I'm sorry, just one moment. Members of the jury, the defendant, Richard Thomas, stands charged in count 1 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 11th day of May 2006 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 2 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 23rd day of December 2011 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 3 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the 25th day of December 2011 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 4 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the first day of January 2012 in Bexar County, Texas. The defendant, Richard Thomas, stands charged in count 5 of the indictment with the offense of sexual assault of a child alleged to have been committed on or about the first day of February 2012 in Bexar County, Texas. To all of these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of indecency with a child by sexual contact if, with the child younger than 17 years of age, and not the person's spouse, the person engages in sexual contact with the child or causes the child to engage in sexual contact. 2, child means a person younger than 17 years of age. Spouse means a person who is legally married to another. Sexual contact means the following acts if committed with the intent to arouse or gratify the sexual desire of any person. Any touching by a person, including touching through clothing, of any part of the genitals of a child, or any touching of any part of the body of a child, including touching through clothing with any part of the genitals of a person. 3, our law provides that a person commits the offense of sexual assault of a child if the person intentionally or knowingly causes the penetration of the sexual organ of a child by any means. 4, our law provides that all persons are presumed to be innocent and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. 5, a person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. 6, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. There's no limitation period for the offense of sexual assault of a child and indecency with a child by sexual contact. Therefore, it is sufficient if the state proves that the offense as alleged in each count were committed sometime before May 19, 2021, which is the date the indictment was filed. 7. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 11th day of May 2006 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly engage in sexual contact with Nina Sanchez, a female child younger than 17 years, by touching part of the genitals of Nina Sanchez with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in count 1 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 1. 8. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of December 2011 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly engage in sexual contact with Nina Sanchez, a female child younger than 17 years, by causing Nina Sanchez to touch part of the genitals of Richard Thomas with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in count 2 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. 9. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 25th day of December 2011 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 3 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3. 10. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the first day of January 2012 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 4 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 4. 11. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the first day of February 2012 in Bexar County, Texas, the defendant, Richard Thomas, did intentionally or knowingly cause the penetration of the sexual organ of Nina Sanchez, a child who was younger than 17 years and not the spouse of Richard Thomas, by Richard Thomas's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 5 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 5. In this case, there was evidence presented of more than one alleged instance that could constitute an offense committed by the defendant, if any. You are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense for purposes of each of the individual counts. You are to consider only that one act as alleged in the indictment by the state in deciding guilt or innocence on that particular count. Evidence of any other alleged act evidence of any other alleged acts is not to be considered unless you believe those acts were committed beyond a reasonable doubt. With regard to those other acts, if any, you are instructed that said evidence was admitted only for the purpose of showing the state of mind of the defendant and the child and the previous and subsequent relationship between the defendant and the child if it does, and for no other purpose. You are also instructed that generally the results of polygraph tests are inadmissible in a criminal prosecution on behalf of the state or the defense. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service or any social media platform, internet chat room, blog or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether the defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any role in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict on each count, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdicts are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict on each count must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
May it please the court, opposing counsel, co-counsel, ladies and gentlemen of the jury. I'm going to go over a few technical matters with you, and then once I'm done, defense will have their time to talk, and Ruben will come after that and make further arguments. So let's start with the technical matters. We're talking about indecency with a child, and here are the elements. On or about some date anterior to the indictment, which is May 19th, 2021, in Bexar County, Texas, the defendant did intentionally or knowingly engage in sexual contact, touching the genitals, anus, or female breasts. It could be over or under the clothes with a child younger than 17 years of age with the intent to arouse or gratify the sexual desire of any person. Those are the elements that the state must prove beyond a reasonable doubt. And those are the elements that the state has proven beyond a reasonable doubt. You've heard from Nina, and you've also heard from the defendant in his confession. He confessed to doing all those things. I think the only thing that's not in the confession perhaps is that it was in Bexar County, Texas, and you heard from Nina. There's basically no dispute about where these accusations occur. So you have that with you in the jury room, the confession, and I urge you to read it and understand exactly what he confessed. The other charge that you'll be deliberating on in the jury room is sexual assault of a child. And we're talking about on or about some date anterior to the indictment, same as the last one. In Bexar County, Texas, same as the last one. Defendant, same as the last one, intentionally or knowingly cause the penetration of the sexual organ, mouth, or anus of a child under 17 years of age. So it's a little bit different. And as you'll see in the indictment, the allegations are alleging this happened in a different time period. The indecency charges counts are earlier in time, and then later in time, there's the allegations of the sexual assault of a child. So one thing I don't want you guys to get hung up on
2 minutes.
is that first section about the jury has to agree that it's on the a date anterior to the date of the indictment. That's May 19th, 2021, as long as it's before that date. That's what's required by law. The legislature understood that the exact date might not always be known in these cases. And every instance that Nina talked about was before that date. And I want to remind you that you're the sole decider of the credibility of all the witnesses that were in front of you. Their testimony is evidence. So any testimony that you believed, you can consider in your deliberations. And the state's position is that Richard's relatives who came in to testify on his behalf were not credible witnesses. They all said that to the idea of whether you should lie for personal gain, they all said it depends. And I think if somebody has that kind of moral, they're not solid in their moral position on lying for personal gain, this is the exact situation where someone would come out and lie for personal gain. This is it, folks. This is when they would come and do that. And so I don't think you can trust them, and I don't think what they said was all that credible. They just seem to have a lot of it depends when asked about whether lying was an acceptable thing to do. And I also want to point out before I go that this is about Nina, and that she was abused by Richard Thomas, and the adults in her life failed her. And they failed her pretty badly. Her mother, the CPS workers, all allowed her to continue to get abused even after Richard admitted that he abused her. And defense said that in their opening that Richard has been waiting a long time for this, and I'll tell you, so has Nina. And don't fail Nina. Please find Richard guilty. And I reserve the rest of my time.
Defense.
Please support.
Yes.
Counselors. Ladies and gentlemen of the jury. I'm not here to tell you who to believe. That's up to you, entirely up to you. And for that, our founding fathers believed the system, and I believe the system. What I am going to ask you is to review that supposed confession. In the law was given by the court, says here, notice, with the intent to arouse or gratify the sexual desire of any person. My client can even spell gratify. He has no degree. He couldn't have written that. That was given to him by Barbara. He signed to get his children. You know, I understand that all these allegations are serious. In fact, I told you, Nina needs help. Told you that from the very beginning. There's no question. This child has been hurt. This child, time and time and time again, continue to make allegations. This child has herself done what she's accusing my client of doing. You heard it. Again, I'm not telling you what to believe. Those are the facts. And the law does not require Richard to prove anything. He doesn't have to. But he wanted you to hear from him why he confessed. By the way, again, read it. It's verbatim. To arouse and gratify the sexual desire of a person. He has no clue what that means. Has no GED, has no high school. He's just a hardworking man looking for his family to provide and protect. And because a child that is troubled, make no mistake about it, she's troubled, makes these accusations. Here we are once again. You heard the evidence say that she recanted. That means she changed her story. Wait, no, it didn't happen. This is when that statement that he signed in 2007, she recanted that. And yet here we are, 16 years later. He couldn't even count. He said 23. 16 years, ladies and gentlemen of the jury. This thing has been going on for 16 years, accusation after accusation after accusation. Poor Nina. She is troubled. In her mind, she has created this fantasy that she's been having a relationship with her stepfather. She's perhaps jealous of the relationship with her mother. Troubled child. And the prosecution wants you to believe one sheet of paper. You're going to take it with you. One sheet of paper. A confession. He confessed. That's it. Makes you wonder what kind of system we are in which that type of behavior. Detective didn't question anyone. 1 hour he spent with her. Oh, she said she's telling the truth. 1 hour. Barbara, 1 hour. That's it. No investigation, no following up, no calling her schools, friends, classmates. Hey, is Nina telling the truth? We believe her. The judge just give you the instruction that polygraphs are generally inadmissible. Read the letter. It was a result of a polygraph investigation in which the examiner makes you lie, then ask you on the examination, have you lied? No, because you're telling me to lie. Oh, there you are. You failed the polygraph test. Ladies and gentlemen of the jury, I suggest to you that if you have children taken away from you and you're dangling something in front of you, says, here, sign this and you got it. He say that he read it. I doubt it. In fact, I bet you if I make him read it, he wouldn't even know how to pronounce half of the words. This is difficult to do when you have people facing you, when you have prosecutors accusing you, when you have the whole world saying you're just guilty. I get it. This type of cases, I get it. I'm asking you to do the honorable thing to do that I requested from each and every one of you, stand firm. The prosecution has to prove to you. Not him. But yet here we did. We brought you, like Paul Harvey says, the rest of the story. Nina has issues. She said it. She's examining her sexuality since 14. She said it. I did it. This is hard. I get it. It's hard. I get it. But not creating an environment in which the whole family is affected by lies. Ladies and gentlemen, this has been time and time again dealt with by the court system. You heard he was in jail. And yet she recanted. Oh no, that's because mom forced her, because grandma forced her. That's the type of story that she creates. And when a person tells the lie time and time again, eventually you believe it. And the story gets bigger and bigger and more detailed. Guys, this is 16 years that she remembers to all this detail. And notice how the prosecution is asking you, oh, sometime between here and there. I asked my children, hey, do you remember that time that you ate that ice cream that you weren't supposed to? Oh, wait, I was 11. I was 12 or 13. No, I don't remember. You heard her 10, 11, 12, 8. Guys, when things like this happen, remember. And the most compelling thing is when something like this happened to you, truly happened to you, you want to get revenge, don't you? You heard her. She doesn't want him to go to jail. It's a fantasy. Oh, she wants him to get registered. No, ladies and gentlemen of the jury, if something like this happened, throw the key and don't just, but it didn't happen. That's why she's giving you the ability to put him on probation. Just don't put him in jail. Ladies and gentlemen, see through the facade and notice how much, I allowed him to talk and the prosecution was objecting, didn't let me ask many questions. I hope you notice that. Because when your case is based on a sheet of paper, I propose that it's thin and is full of reasonable doubt. We don't have a definition. You get to say what is reasonable doubt, but question each and every instance. Question why the detective did not follow up. Question why Barbara had him say the same language as, the same verbatim. Ask why would anyone, if heard, will tell the perpetrator or the alleged perpetrator, that's okay, you can just be a register, don't go to jail. Only if this is a story in your head, a facade that you just want to, like a story, a love story. Oh, I believe she's in love with him for some reason. She needs help, ladies and gentlemen. But the court says, do not feel sympathy. You're not here because do not let, the court instructed, you are not to let bias, prejudice, sympathy. I feel sympathy for her. She needs help. But we cannot have that ruling based on that. I despise sexual predators. They need to be taken care of, but not honest men based on a paper-thin confession and based on a story that continues to be bigger and bigger. Ladies and gentlemen, she said that this story was recanted. She said it, not over here. Finally, please notice that confession, if you remember, the prosecution wanted to hide that paper, and we had a discussion, Exhibit 2 and 2A. It's the only exhibit you have, 2A. They wanted to redact that part about the polygraph. That's how it was obtained, through a polygraph. You are also instructed generally the results of a polygraph test are inadmissible. Either for the criminal prosecution or the defense. This is why you didn't see the actual polygraph. It's inadmissible. Yet, that confession is because of it. Does that make sense? Only when a person feels so much empathy, will a person believe a story as grand as Nina. I mean, geez, having sex, losing her virginity, and she's standing up. I have girls, and I don't ask about those questions, but I know that there's some parts of their story that it just makes no sense. If at 14, she had blood and she had semen, why didn't she say, Mom, I've been telling you all these years, here it is. Go take that to the, never happened. It's the only plot. If you have the person that is abusing you, supposedly, now you have proof. Oh, well, it's not there. Again, she had the time to truly get this done. The investigators had the time, everybody. When the prosecutor says they failed, the system has failed, the state has failed, truly, because this case should have been dismissed. They knew this. They knew that she recanted her story. They knew that she's got some issues. They're expecting a juror of his peers to feel sorry for her. And make no mistake, I told you from the very beginning, she needs help. She needs help. But please, do what you said you were going to do. Stand firm for our founding fathers' values, that he is innocent until proven guilty. They have to prove him guilty. I believe that a piece of paper doesn't do it. That's the only thing you're gonna be able to take back. That's it. And you're gonna see that it matches exactly what the indictment says. Something that Richard could have never thought about saying, other than against his children. I understand that that sounds very far-fetched, but that's what happened. The state, CPS, call it placement, removed them. Those children were not at their residence, period, where they're supposed to be sleeping at night. And for them to come back, I needed something from him. And they got it. And here we are, 16 years later. Ladies and gentlemen, this is the jury,
2 minutes.
thank you, Your Honor. The credibility of each witness is up to you. The weight of the evidence is up to you. I'm gonna ask you when you go back to stand firm, just like the judge is asking you. Don't be persuaded, but you can change your opinion, but fight. If something inside of you telling you this is not right, fight. Do not give up because you want to go home Friday. Trust me, I want to go home, but I want this to be done properly. Now it's up to y'all. Y'all to come up with a verdict. Find my client not guilty 5 times because the story, he is not guilty. You saw him. He told you this is in Nina's head. Find him not guilty. Thank you so very much. My client thanks you. The family thanks you. May God bless you and may God bless the United States of America.
Right, state.
Ladies and gentlemen of the jury, there's only one facade that's being pushed to you here today. And that's the facade that the defendant wants you to believe. He wants you to believe that he was coerced into a confession to sexually abusing one of the kids that was in his care, and that he was going to get his children back after admitting to sexually abusing one of them. Does that make sense to anybody in this courtroom other than the defendant? The defense is trying to confuse you with multiple different arguments about what could have happened. Why could Nina have done this? There's only one thing at issue in this case, And that's what the defendant did to Nina on 5 different occasions. You have the confession, which defense is making a big point about. And I want you to remember one thing. That confession came from the defendant calling up Belinda Castellanos, asking her for a meeting so he can come in and confess. And Belinda told you he didn't write that, they wrote it, but they gave him every opportunity to read it, edit it for its truthfulness before he signed it, and signed in front of a witness as well. So consider that. You also heard Nina's testimony, and she has been consistent from the beginning. She told all of you that starting in 2006, there was only touching, which is corroborated by the defendant's own confession. Defense made a big deal about the dates and how she was still a virgin in 2006. Well, of course she was, because she's never told anybody anything different. The sexual abuse, the sexual penetration didn't start until 2011 after she turned 14. She told you all that, and that's corroborated by their own arguments. She was able to tell you that the first time she had sex with the defendant, when she lost her virginity, she was standing up. She remembered that detail. She told you in 2006, she remembers when he put his genitalia on her back, she felt it wet through her clothes. She remembered that detail. She has remembered details from each incident through 16 years that this has been going on. Her testimony is credible. None of her testimony has changed over the 16 years. And sure, she does have some flaws. She's not a perfect person, and she never claimed to be. She told you all upfront and honestly that she engaged in a relationship with the defendant when she was under the age of 17 years old. She admitted all of that. Why would she admit that if it wasn't true? Wouldn't it be more reasonable to believe that she was raped? And if she really wanted to make a lie and have people believe her, isn't that a little bit more believable? No, but she was honest with each and every one of you and told you that it was consensual. But again, remember, she's under the age of 17. She can't consent. But you know who should know right from wrong? The defendant. She admitted to running away. But what else would you expect from a child who's not protected by her parents? She's in a home where this abuse is being allowed to happen. What other choice does she have? And she admitted to not even being the perfect sister to Jacqueline. She admitted she harmed her physically. But the defense wants to throw out that she was sexually abusing Jacqueline. Where is the report? Where is any evidence that anything sexual happened between any of them other than Jacqueline's testimony? Who I will also remind you, as Travis told you, said that it depends whether or not you should lie in order to benefit yourself. You can't believe anything she said. And who has the motive to lie here? Does Nina? The defendant's not in her life anymore. She has no reason to get back at him. Her mom's not in her life anymore. She has no reason to get back at her. If she's trying to get him out of her life, he already is. You know who has the motive to lie here? The defendant. Because he's the one on trial here. He's the one that's facing time in prison. So of course he's gonna lie. And his own family told you that sure, it depends. Maybe you should lie when it's gonna benefit yourself. Each and every one of them told you that on the stand. But you know what they also said? They also said they wouldn't admit to a crime that they didn't do, which is what the defendant wants you to believe he did. He wants you to believe he never did this, but he admitted to it to get his children back. First of all, again, that makes no sense. How would you put children back in the care of someone who just admitted they sexually abused a child? You also heard from Belinda that nobody took the children away from them. Santa took the children to her mother's house to get away from the defendant after he admitted that he sexually abused Nina. Ladies and gentlemen, use your common sense when you evaluate that confession. Does the defendant's story make sense? Or does it make more sense that he did that and wanted to confess to it? Everybody's been talking about failures today. And yes, Nina's been failed by all of the adults in her life. She was failed by the defendant, her stepdad, who sexually abused her and manipulated her family against her to the point where none of them believe her and are on her side. She's failed by her mother, who failed to protect her from the sexual abuse and allowed her admitted, confessed sexual abuser back into the home. And that was before the sexual abuse, the sexual penetration even occurred. She was failed by CPS, who, under the wrong assumption that Santa was going to protect Nina, allowed Nina back into the home. And they didn't follow up to know whether or not the defendant was back in the home. I'm urging all of you to not be an additional step of failure in Nina's life. She told you that she's okay with him getting probation.
Yes, I'm gonna object improper jury commitment. And the closing argument, Your Honor.
All right, overruled.
They said she's okay with probation because, like I said, she has nothing to gain. The defendant's already out of her life. What's the difference to her if he's in prison or not? But you don't have to consider that at this point. What I'm asking you to do is find the defendant guilty on all 5 counts and hold him accountable for his actions, which is what Nina said that she's still here 16 years later to do, even though she gets no benefit from this. Thank you.
All right, ladies and gentlemen, I'm going to let you retire back to the jury room. I'm going to ask for Alonso and Sosa, if you could remain behind, please. Everyone, please rise for the jurors. Please be seated. If I could see defense and state.
Instructions still apply to both of you. You're not allowed to do anything. You're not allowed to start deliberating in terms of each other. Everything that you need to know about this case is come from inside the children. You won't be allowed to go back and them to deliberate either, okay? So Deputy Laura's will let you know place to hang out. And then we'll call you if you're needed. So it's something where it happens to one of the jurors, then we'll let you in deliberation with them, okay? Yes, Deputy Laura will take you to get those objections. Taking them back there to get their belongings. All right, thanks. All right.
I think Joseph.
Can you grab them real quick for me, please? Oh, and I found it in my purse. It was hidden. Yeah, that's one.
Like, I mean,
I'm still able
it
to-
wasn't a problem. Well, no, I mean, just like I should have known that it would have taken more than 2 minutes so that I wouldn't feel rushed when I got my 2-minute warning.
All right, Diane, are you ready? And then later, I guess you need to do the exhibits.
Yes.
All right. Oh, I'm so sorry, guys. Yes, she's going to give the exhibits, and just remember 2 is not going back there. Yes. Oh, only 2A was it, Bennett?
Yes, ma'am.
Oh, okay. Yeah. All right, Mr. Aguilar, if you want to come down. And then Hank, if you'll just ask that this be added to the STIPs. And has your client had a chance to see what's being added to the STIPs? Okay. 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 All right. All right. You ready? We're going to go back on the record in 2023 CR 4007A, State of Texas versus Mario Aguilar. Can I have parties announced for the record for the state? Thanks. Okay. And with regards to the waivers and stipulation of testimony and stipulation state, any additions?
Yes, Your Honor, we would like to, add Stacy to the one to add the prosecution side, given the defense that they.
Any objection?
Your Honor, we have no objections.
All right. And you understand what's being added, Mr. Aguilar? All right. The court will find, based upon state's exhibits 1 and attachments and the stipulations what the court has is accepting the record, and the court is finding that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will find there's sufficient evidence to find the defendant guilty. The court will defer finding of guilt because the defendant has applied for deferred adjudication. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client? So how old are you? Do you have any children? All right. Any drug issues for you? Are you employed? Have you ever been employed?
Yes, Your Honor.
Doing what?
Working at a restaurant, going on painting, remodeling,
All right. And how far did you go in school?
high school.
Did you graduate? Why not?
I got into a program and learning academy and I felt so I can go to work.
Okay. All right. And I see that he is a resident and not a citizen. All right. So whether or not the federal government removes you, that's under their purview. That is not my purview. I do not have any control over that. Do you understand?
Yes, Your Honor.
And legally, I cannot remove you. You understand? All right. Yes. Mhm.
There are that.
So does he have a hold?
He has a hold, but he's released on the bond.
All right. There's going to be a $500 fine. That will be probated. 8 years deferred adjudication. There's to be no contact with Emmanuel Nathaniel Morley, Morley Jr. There's to be no contact with Charles Williams. There's to be the theft course and the MRT course. Is there any restitution that's due to the complainant?
No, Your Honor.
There should be regular reporting by Zoom or in person regular UAs. If you were released, who are you living with? All right. So probation,
Yes, Your Honor.
if he is released by the federal government and they put him on the monitor, then it's fine for us to just have him on that monitor. But if he is not released without a monitor, then we will put him on a monitor. And that will be 90 days GPS. And it'll be partial for work. There's to be 200 hours of community service restitution. Those hours will be waived if you obtain your GED or if you're in some sort of trade school. You need to have some sort of skill so that you can have employment. You understand? And you say you're residing with your grandmother. Does your grandmother want you residing with her? Did you ask her?
Already, when I came from immigration, that's what my had to say.
Okay. Defendant to reside with grandmother. Is that your maternal grandmother or paternal grandmother? Is it your mother's mother or your father's? Okay. So he's to reside with his maternal grandmother upon verification. There's to be proof of employment. Within 40 days of release. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs?
Your Honor, do you want any field visits?
Yes. Let's do field visits. One time per month for 3 months. And then if probation feels that everything is going as it should be, then you can do those randomly. All right, is there anything else, probation?
No, Your Honor.
All right, is there anything else you need from the court to be successful?
No, Your Honor.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Look, you're a resident. Maybe they're going to deport you. Maybe they will not deport you. But while you are here, you need to do better. You understand?
Yes, Your Honor.
People already have an eye on you because you're a resident and you're not a citizen. You make it harder for other people when they are residents and they're doing the right thing. Because then people are, there goes another resident who's committed an offense. There goes somebody who's not a citizen who's committed an offense. And you make sure that people are able to paint a brush that residents and that people who are not here are not doing what they're supposed to do and are not being law-abiding people. Do you understand?
Yes, Your Honor.
You're going to have to do better. You understand?
Yes, Your Honor.
And do not go to your grandmother's house if you are released and cause problems for her, because she does not need any trauma or drama coming to her doorstep. You understand?
Yes, Your Honor.
And if you're going to be staying with her, guess what? You're not an adult. You need to follow her rules. If she tells you she wants the television off by 10, that TV needs to be off by 10. If she tells you she doesn't want any of your friends coming over, then your friends can't come over because that's not your house. That's her house. You are now an adult. You understand?
Yes, Your Honor.
All right, do better. Good luck to you.
Thank you, Your Honor.
Oh, by the way, do you need anything else from the court?
No, Your Honor.
All right, what's that? I just noticed. What's that tattoo on your hand?
What are you saying?
All right, do a gang evaluation as well, please.
Yes, Your Honor.
All right. Thank you.
Thank you, Judge. Good luck to you. Let me excuse, Judge.
Yes, you may. Thank you so much for coming back.
Of course, Judge. Have a good weekend.
All right, you too. And I think that's the last person we have on the docket.
Yes, ma'am.
All right, thank you. Good seeing you.
Almost back there?
It's, yes.
Okay, good deal. I've got a fellow who didn't show up for PTD, so I just want to make sure he's